Before we begin, please note that this presentation is for informational purposes only and does not constitute legal advice. The information provided is not a substitute for professional legal counsel from a qualified attorney licensed in your state. The content of this video is not intended to create, and receipt of it does not constitute, an attorney-client relationship. You should not act or refrain from acting based on this information without seeking the advice of an attorney. You're staring at the ceiling at 2 in the morning. The argument from 3 hours ago is still echoing in the silence. And you did it. You picked up your phone, opened a private browser window, and typed the words, "How to start a divorce in NYC." And now you're here, feeling a mix of terror, relief, and a profound sense of being completely and utterly lost. Your mind is racing with 1,000 questions. How much will this cost? What happens to the kids? Where will I live? Will I be financially ruined? You feel like you're standing at the edge of a cliff, and the only next step is to jump. But what if I told you that thinking about filing for divorce right now is the single biggest mistake you can make? What if I told you that the legal filing, the piece of paper that officially starts the process, is actually step 5? Or maybe even step 6? And that the first 4 steps, the ones you take in secret, in the quiet, before your spouse even knows you've made a decision, will determine the entire trajectory of your future? They will determine whether this process is a strategic, controlled transition or a financially devastating, emotionally shattering war that leaves you broken for years to come. This is not about how to get a divorce. This is about how to prepare for one. It's about taking back control before the system takes it from you. Because in a New York City divorce, the person who is best prepared, not the person who is most right, almost always comes out ahead. And that preparation starts with a lawyer, but not in the way you think. Most people believe you hire a lawyer to file papers and go to court. That's like hiring a world-class architect only after the foundation of your house has been poured incorrectly on unstable ground. The true power of a great divorce attorney is unleashed before the case is ever filed. This initial phase is what we call the strategic planning session. It's not about aggression, it's about intelligence. It's not about starting a fight, it's about building a fortress. So, what is the very first thing a lawyer does with you behind closed doors before anyone else knows what's happening? They help you conduct a comprehensive life audit. Think of it as a deep dive investigation into your own life, but with an expert guide who knows exactly what clues to look for. You can't negotiate a settlement, you can't ask a judge for anything, you can't even make a rational plan for your own future until you know with absolute certainty what you have, what you owe, what you earn, and what you spend. This sounds simple, but I promise you 99% of people who walk into my office have, at best, a foggy idea. They think they know, but they don't really know. And in divorce, what you think you know can destroy you. So we start with the financials. This is the bedrock of everything. Your lawyer's first job is to give you a detailed homework assignment. It's a scavenger hunt for your own life. We need everything. And I mean everything. 3 years of bank statements for every single account you and your spouse have, joint or separate. 3 years of credit card statements for every card. We need mortgage statements, car loan documents, student loan records. We need the last 3 to 5 years of tax returns, both personal and for any business you or your spouse might have an interest in. We need pay stubs. We need retirement account statements, 401(k)s, IRAs, pensions. We need investment account statements from Morgan Stanley, Fidelity, Robinhood, whatever you use. You might be thinking, my spouse handles all of that. I don't have access. This is the first and most critical hurdle. Your lawyer will give you strategies for gathering this information. It might be through online portals you have access to, through mail that comes to the house, or from your accountant. The key is to gather as much as you can before you announce your intentions. Because the moment you say the word divorce, the digital and paper trails can mysteriously vanish. Passwords change. Documents get lost. Your spouse, who was once your partner, is now your adversary. And their first move will be to control the flow of information. By gathering it beforehand, you're not being sneaky, you're preserving the truth. You are capturing a snapshot of your marital life as it actually exists, before anyone has a chance to rewrite history. I had a client once, a stay-at-home mom. She believed the family had about $100,000 in savings and a modest retirement fund. Her husband told her they were comfortable but not rich. During our pre-filing audit, we uncovered 3 different investment accounts she never knew existed, totaling over $1.2 million. We also found a credit card in his name only, with $80,000 of debt from trips and gifts we couldn't account for. Imagine if she had walked into negotiations believing the family pot was just a fraction of its real size. Or worse, agreed to take on half of a secret debt she had no part in creating. That's the power of this initial audit. It replaces assumptions with facts. But the audit isn't just about assets and debts. It's also about lifestyle. Your lawyer will have you meticulously track your family's spending. We call this a statement of net worth analysis. How much do you spend on groceries, utilities, the mortgage, the kids' activities, vacations, car payments, clothes? We need to build a picture of your marital lifestyle. Why? Because in New York, concepts like spousal support or maintenance and child support are directly tied to this. You can't just say, "I need $5,000 a month to live." You have to prove it. You have to show the court that this was the established standard of living during the marriage. The person with the detailed budget and the receipts to back it up has an incredible advantage over the person who just throws a number out there. Beyond the financials, the pre-filing audit covers the personal landscape. Your lawyer will ask you to create a detailed timeline of your marriage. Major events, moves, career changes, the birth of your children. Who has been the primary caregiver for the children? Who takes them to doctor's appointments? Who communicates with their teachers? These details feel small, but in a custody dispute they are mountains of evidence. They establish a status quo, a history of parental involvement that is incredibly persuasive to a judge. Your lawyer is helping you build the narrative of your role in the family, supported by calendars, emails, and school records, long before you ever have to tell that story in court. Finally, we look at the digital world. We live our lives online, and in a divorce, your digital footprint is a treasure trove of evidence. Your lawyer will advise you on how to handle your social media. Hint: stop posting immediately. They'll discuss the role of emails, text messages, and direct messages. It's crucial to understand that anything you write can and will be used against you. A stray, angry text sent in a moment of frustration can become Exhibit A in a custody battle. Your lawyer's early advice here isn't about hiding things. It's about preventing you from creating evidence that can be twisted and used to harm your own case. It's about professionalizing your communication from this moment forward. This entire process, this deep, comprehensive audit of your financial, personal, and digital life, is the foundation. It's the work you do in the quiet that allows you to act with strength and clarity when things get loud. Your lawyer in this pre-filing stage is not a warrior. They are your strategist, your private investigator, and your coach. They are helping you map the entire battlefield, understand your own strengths and weaknesses, and anticipate your opponent's every move, all before the first shot is ever fired. Doing this work first transforms your mindset from one of fear and uncertainty to one of empowerment and control. You stop being a victim of your circumstances and start becoming the architect of your future. So let's talk about what being the architect of your future actually looks like. It begins with a single powerful action: switching on the lights. Right now, you might feel like you're in a dark room, bumping into furniture, unsure of the layout. You know there's a door somewhere, but you can't find it. Your first job, with the guidance of a strategic lawyer, is to find the light switch. This isn't about filing motions or serving papers. It's about illumination. It's about conducting a thorough, confidential, and strategic inventory of your life. We call it creating a financial X-ray. Think about it. A doctor would never perform surgery without first looking at an X-ray or an MRI. They need to see what's happening beneath the surface, where the bones are, where the nerves are, where the damage is. To operate without that information would be malpractice. The same is true for divorce. Walking into a divorce without a crystal-clear picture of your complete financial landscape is legal malpractice you commit against yourself. You're operating blind, and you're the one who will bear the scars. Many people who come to me are in a state of what I call financial fog. One spouse, often the higher earner or the one who was just more interested in it, handled the money. They paid the bills, they managed the investments, they filed the taxes. The other spouse was happy to let them. Seemed easier that way. It was a sign of trust. But now that trust has eroded, and the fog is terrifying. You don't know how much money there is. You don't know where it is. You don't know how much debt you're in. You might have a vague idea, but vague ideas get destroyed in a New York divorce court. Let me tell you about a client. We'll call her Brenda. Brenda was married for 18 years to a successful executive. She raised their 3 children, managed the household, and supported his career every step of the way. He always told her, "Don't worry about the money, I've got it handled." And she didn't. When she came to my office, her marriage was broken beyond repair, and she was terrified. He had told her they were house poor, that all his income went to the mortgage and the kids' private school. He said if they divorced, she'd be lucky to get enough to rent a small apartment. She believed him. She was ready to accept a tiny fraction of what she was entitled to, just to escape the emotional turmoil. She was operating in that financial fog. Our first step, we didn't talk about filing. We didn't draft a single court document. We launched an intelligence-gathering mission. I gave her a precise checklist. Her mission, should she choose to accept it, was to become the world's leading expert on her own life. Quietly, discreetly, without raising any alarms. This is your first task. You need to gather the documents that tell the true story of your marriage, not the story you've been told. This is the blueprint for your financial X-ray. First, we look at income, the story of what comes in. We needed her husband's pay stubs for the last year. Not just one, all of them. Why? Because pay stubs reveal the truth about bonuses, commissions, and other compensation that might not show up on a tax return. We needed the last 3 to 5 years of personal and business tax returns, including all the schedules and W-2s. Tax returns are a roadmap to a person's financial life. They show us not just salary, but interest and dividend income, capital gains, and business profits. For Brenda, we discovered her husband wasn't just getting a salary. He was getting substantial deferred compensation and stock options he'd never mentioned. The house poor story was beginning to crumble. Second, we map out the assets. The story of what you own. This is where the real digging begins. We needed bank statements for every single account for the last 3 years. Checking, savings, money market accounts, everything. We're not just looking at the balance. We're looking at the flow. Where is money coming from? Where is it going? Are there large unexplained transfers? Are there regular payments to an account you don't recognize? We needed statements for all investment and retirement accounts. For 401(k)s, IRAs, brokerage accounts, pension statements. These are often the largest assets in a long-term marriage, and people often have no idea what they're worth. Brenda thought they just had one small retirement account. We found 3, and one of them was worth over $1 million. We also needed copies of deeds to any real estate. The house, a vacation condo, a rental property. We needed the titles to all vehicles, cars, boats, motorcycles. And then I had her do something that felt strange. I had her walk through her house with her phone and take pictures of everything of value. Art, jewelry, antiques, expensive electronics. People forget these things, but they are marital assets that need to be valued and divided. Third, we uncover the debts. The story of what you owe. This is just as important as the assets. We gathered statements for all mortgages and home equity lines of credit. We pulled statements for every credit card for the last 2 years. Credit card statements are a treasure trove of information. They tell a story about lifestyle. They can reveal hidden expenses, travel you didn't know about, even money being spent on an affair. We collected documents for all other loans. Car loans, student loans, personal loans. You need to know the total debt picture because debt gets divided in a divorce too. You don't want to be surprised with a $50,000 credit card bill in your name that you knew nothing about. Brenda spent 2 weeks on this mission. She'd wait until her husband was at work or asleep, and she'd calmly and quietly scan documents to a secure cloud drive that he had no access to. Every document she found was another light bulb turning on in that dark room. With every statement, every tax return, the financial fog began to lift. She wasn't just finding papers, she was finding her power. She discovered that the narrative her husband had fed her for years, that they were struggling, that she would be destitute without him, was a complete fabrication. It was a control tactic. By the time she was done, we had a binder, both physical and digital, that contained the complete, unvarnished financial truth of her 18-year marriage. She walked into my office a different person. The fear was gone. The uncertainty was gone. It was replaced by a calm, cold clarity. She wasn't guessing anymore. She knew. She knew what they had, what they owed, and what the real numbers were. This is the power of doing the work before the war. You're not just collecting paper. You are arming yourself with facts. And in a divorce, facts are your ammunition, your shield, and your sword. It allows your lawyer to build a strategy based on reality, not on your spouse's fiction. We could now project with a high degree of accuracy what a fair settlement for Brenda would look like. We could calculate potential child support and alimony based on his real income, not the number he wanted her to believe. This preparation changes everything. It shifts the entire balance of power before the other side even knows there's a game being played. You move from a position of weakness and ignorance to a position of strength and knowledge. You stop reacting to their threats and start acting on your plan. But gathering the paper trail is only the first layer. It's the foundation. In our modern world, the most critical and often most damning information isn't stored in a filing cabinet. It's digital. It's on phones, on laptops, in the cloud, on social media. And what you don't know about your digital footprint can absolutely destroy your case. The very device you're using to watch this video could be your greatest liability. And the scary part is, your spouse might already be one step ahead of you. Because while you're thinking about fairness and an amicable split, your spouse might be waging a silent digital war. They might be using shared accounts you've both forgotten about to monitor your every move. Think about it. That shared iPad the kids use for games? If it's logged into your iMessage account, they're seeing every text you send and receive. That Amazon Prime account you both use? They can see your purchase history, your wish lists, even what you've been searching for. The Google Photos account that automatically backs up pictures from your phone? It's a real-time diary of your life that they have the key to. This isn't a spy movie. This is the reality of a 21st century divorce in New York City. Let me tell you about a client we'll call David. David came to us convinced his divorce would be simple. He and his wife Sarah had just grown apart. No big drama, he said. He was ready to be fair, split everything 50-50 and move on. He'd been careful. He deleted texts from a new friend, cleared his browser history, and changed his main email password. He thought he had scrubbed his digital life clean. He was wrong. Fatally wrong. What David didn't know was that Sarah had seen a lawyer 3 months earlier. Her lawyer didn't tell her to go on the attack. They told her to go on the defense. To observe. To document. Sarah's lawyer instructed her to conduct a quiet audit of their shared digital life. Sarah remembered the old laptop in the study they hadn't used in years. She booted it up. And there it was. David's Dropbox account still logged in. It wasn't synced to his current files, but the old cache was still there. And in that cache, she found a file he'd created 2 years prior. It was a detailed financial spreadsheet. A Plan B, he'd called the file. It listed financial accounts she never knew existed. An offshore account with a small but significant balance. A separate brokerage account he'd been funding with small regular transfers from his business that he'd always described as struggling. It didn't stop there. Their EasyPass toll account, which they shared, told a story. It showed his car repeatedly crossing the George Washington Bridge late on Tuesday nights and returning in the early hours of Wednesday morning, directly contradicting the late nights at the office narrative he'd been selling her for months. The Venmo transactions, which are public by default unless you change the settings, showed a pattern of payments to one particular person for dinner, drinks, and fun, all decorated with inside joke emojis. When David sat across from us in our office, he was confident. When we later sat across from Sarah and her lawyer in a conference room, they quietly laid out printouts. The spreadsheet from the Dropbox, the EasyPass records, the Venmo history. The color drained from David's face. His simple, amicable divorce was now a complex, high-stakes battle where his credibility was already shot. He wasn't just facing a divorce. He was facing allegations of financial fraud and dissipation of marital assets. His attempt to clean up his digital life was a child's crayon drawing against a masterpiece of digital evidence. He deleted a few texts, while she had uncovered a multi-year narrative of deception. This is the first job of a lawyer before you file. To transform you from a potential victim into a digital forensic analyst. They tell you to stop deleting and start documenting. Deleting evidence, a term lawyers call spoliation, can have catastrophic consequences. If a judge believes you intentionally destroyed evidence, they can infer that the evidence was unfavorable to you. They can hit you with massive financial sanctions. They can even decide a contested issue in your spouse's favor as a punishment. So you don't delete. You preserve. You take screenshots of text messages, making sure the date and time are visible. You download bank statements. You photograph financial documents. You create a secure, private cloud account, accessible only to you and your attorney, and you start building a library of facts. Your lawyer will guide you through what we call a pre-filing digital lockdown. This isn't just about changing your Facebook password. It's a systematic process of severing the digital ties that could be used against you. Step 1 is securing your email. Your primary email account is the skeleton key to your entire digital life. If your spouse has access to it, they can reset the password for every other account you own, your bank, your social media, your cloud storage. You change that password immediately, and you enable two-factor authentication. This is non-negotiable. Step 2 is a device audit. Log out of your accounts on every shared device. The family computer, the shared tablet, the smart TV. Every single one. Put a new complex passcode on your phone and your personal laptop. Don't use your birthday or your kid's birthday. Think of your phone not as a communication device, but as a locked vault containing the evidence for your case. Step 3 is the social media blackout. This is often the hardest for people. Your lawyer will tell you to stop posting. Period. Go completely dark. Make all your accounts private. Why? Because every post is a potential exhibit. That picture of you having a glass of wine with friends? Your spouse's attorney will frame it as evidence of a drinking problem, arguing you're an unstable parent. That check-in at a fancy restaurant? They'll argue you're wasting marital assets while claiming you can't afford support. Your social media is a self-surveillance tool you are voluntarily handing to the opposition. A good lawyer tells you to turn it off. They will also tell you to review your friends list. That friendly acquaintance of your spouse who just sent you a friend request? They might be a scout sent to gather information. You unfriend, you block, and you go silent. This isn't about being paranoid. It's about being prepared. The court system in New York is an adversarial system. Presumes you and your spouse will be fighting. The evidence you gather or fail to gather in these crucial weeks before filing can determine the trajectory of your entire case. It can be the difference between a fair settlement and a financial disaster. It can impact custody, equitable distribution, and spousal support. Think about the financial data. A lawyer will tell you to download the last 3 to 5 years of every financial account you have access to. Bank accounts, credit card statements, mortgage statements, brokerage accounts, 401ks, crypto wallets. Everything. You might think, why? We'll just exchange this in discovery later. Because you might not have access later. The moment you file for divorce, your spouse might lock you out of joint accounts or move money from accounts you can see to accounts you can't. The documents you download today are your baseline. They are the before picture of your marital financial life. Without it, you're trying to solve a puzzle with half the pieces missing, while your spouse holds the picture on the box. This process is your armor. It's your shield. When you walk into the legal process, you want to do so from a position of strength, armed with organized, undeniable facts. You don't want to be like David, blindsided and backpedaling, trying to explain away years of digital breadcrumbs he didn't even know he was leaving. You want to be like Sarah, calm and prepared, with a clear factual foundation for your case. Her lawyer didn't make her a villain. They made her a strategist. They helped her secure her position before the first shot was even fired. By taking these steps, you and your lawyer are building a fortress of truth around your case. You're ensuring that the story told in court is the real one, not a fictional narrative crafted by your spouse. You've locked down your digital life, you've preserved the evidence, and you've built a digital fortress. But all of that work can be for nothing if your spouse pulls off the single most common and most devastating pre-divorce maneuver, hiding the money. And they don't do it by stuffing cash in a mattress anymore. They use sophisticated corporate veils, shell companies, and financial tricks that can make hundreds of thousands of dollars vanish overnight. And your lawyer's next job is to become a financial detective. They call it the discovery phase of a divorce, which is the most boring, sterile name imaginable for what it really is. A full-scale financial investigation. This isn't a friendly exchange of paperwork. It is a legally sanctioned siege. Your lawyer is the general, and their first move is to deploy the heavy artillery. The most powerful weapon in their arsenal is the subpoena. A subpoena isn't a request. It's a demand, backed by the full force of the New York court system. It's a legal key that can unlock doors your spouse has welded shut for years. And your lawyer will send them everywhere. A blizzard of subpoenas will go out to every financial institution you've ever touched. Banks, credit unions, brokerage firms, mortgage lenders, credit card companies. We're not just asking for the last 3 months of statements. We're demanding years, sometimes a decade, of records. Every check written, every wire transfer sent, every credit card charge, every stock purchased or sold. We want the loan applications where your spouse likely inflated their income to get that mortgage, and we'll compare it to the tax returns where they deflated their income to pay less to the IRS. The hypocrisy is often staggering, and it's pure gold in court. But it doesn't stop there. Does your spouse have a pension? We'll subpoena the plan administrator. A 401k? We'll subpoena the investment house. Did they get a big inheritance 5 years ago they claimed was all gone? We'll subpoena the records from the estate to see exactly how much it was and where it went. We are building a financial map, and every subpoena fills in a missing piece of the continent. The next weapon is the deposition. Imagine your spouse, sitting in a sterile conference room, under oath, with a court reporter transcribing every single word. For hours, your lawyer will question them. There's nowhere to hide. There are no evasive texts or dodged phone calls. It's a slow, methodical dismantling of every lie and half-truth they've ever told you about money. On your 2022 tax return, you claimed your consulting business only made $40,000. Is that correct? Yes. But on this American Express statement from that same year, we see a charge for $60,000 for a down payment on a boat. Can you explain how a business that only made $40,000 could afford a $60,000 boat? The silence in that room can be deafening. This is where the story unravels. We ask about the business trips to Miami that coincide with Art Basel. We ask about the consulting fees paid to a company that, upon investigation, is just an LLC registered to their best friend. We ask about the Venmo transactions with vague descriptions that happen every single month like clockwork. Under the pressure of a deposition, the carefully constructed facade begins to crack. But even with all this, a smart lawyer knows their limits. A lawyer is an expert in the law, not necessarily in forensic accounting. So they bring in the specialist, the bloodhound, the person who lives and breathes numbers, the forensic accountant. This is the secret weapon in high-net-worth New York divorces. A forensic accountant can look at a spreadsheet and see a story. They can take a mountain of raw data, bank statements, tax returns, credit card bills, and find the single transaction that blows the whole case wide open. They are trained to spot anomalies. Why is a dental practice buying $10,000 worth of concrete every month? Why is a hedge fund manager suddenly paying a massive management fee to a brand new company in Delaware right after being served with divorce papers? Let's talk about a classic New York scenario. The cash business. Your husband owns a string of pizzerias in Queens. He claims he's barely scraping by, that the business is on the verge of collapse. He shows you tax returns that prove it. You know he's lying. You see the cash. But how do you prove it? Your lawyer and the forensic accountant get to work. They don't just look at his books. His books are a work of fiction. They look at everything else. They subpoena the suppliers. How much flour, cheese, and tomato sauce has he been buying? They do a simple calculation. If he bought enough cheese to make 500,000 pizzas, but he only reported sales for 200,000 pizzas, where did the money from the other 300,000 pizzas go? It went into his pocket. They pull his utility bills. A business that's barely open, doesn't have a gas bill consistent with ovens running 18 hours a day, 7 days a week. They might even go and sit in the pizzeria for a few days counting customers, observing how many pay with cash versus credit. They build a model of what the business should be making, based on reality, not on the fraudulent numbers he's reporting. Suddenly, his failing business is revealed to be a cash cow, and your share of it just grew exponentially. Or consider a more sophisticated Wall Street scenario. Your wife is a private equity partner. Her compensation is a labyrinth of salary, bonuses, carried interest, and deferred compensation. She tells you, the big payday is years away, it's not marital property, you're not entitled to it. Your lawyer's response is, that's cute, but it's wrong. The work she did to earn that future payday happened during the marriage. Her long nights at the office, the trips to London and Hong Kong, that was all marital effort. Therefore, a portion of that future payment is marital property. The forensic accountant is brought in to perform a complex valuation. They analyze the fund documents, project future earnings, and calculate the present-day value of her interest. It's a highly specialized skill, and it can uncover millions of dollars that a less experienced team might leave on the table, simply because they didn't know how to look for it or how to value it. And what about the cutting edge of hiding money? Cryptocurrency. People think it's the perfect way to hide assets. Anonymous, untraceable digital gold. They are mistaken. It's often clumsier than hiding cash. To buy significant amounts of crypto, you usually have to use a regulated exchange like Coinbase or Kraken. You have to link a bank account, and that creates a paper trail. We subpoena the bank and see the wire transfer to Coinbase. Then we subpoena Coinbase and demand a full transaction history. We can see they bought 10 Bitcoin. Then we trace where those Bitcoin went from the exchange. Did they go to a private wallet? We can see that on the blockchain. The blockchain is a public ledger. It's anonymous, but it's not invisible. Uncovering crypto isn't magic. It's just meticulous modern detective work. This entire process, this financial excavation, serves one critical purpose: to establish the truth. It's not about revenge. It's about justice. It's about ensuring that the division of assets is based on the reality of your shared life, not on a fiction created by one spouse to cheat the other. It levels the playing field. The spouse who controlled the money, who held all the information, loses their primary advantage. Knowledge is power, and your lawyer's first job is to seize that power and share it with you. Once this financial map is complete, once every dollar is accounted for, and every hidden asset is dragged into the light, only then can you begin to have a meaningful conversation about settlement. Because now you're not negotiating in the dark. You're negotiating from a position of strength, armed with undeniable facts. You've found the secret accounts and the hidden business ledgers. You've won the battle, right? Not even close. Because finding an asset is one thing. Proving what it's actually worth is a completely different war. And welcome to the most deceptive battlefield in a New York City divorce: the fight over value. This isn't a fight with spreadsheets and calculators. It's a psychological war fought with appraisals, expert witnesses, and competing versions of reality. Your spouse isn't just going to hide an asset. They are going to look you straight in the eye and tell you that the thriving business you helped build from the ground up is suddenly on the verge of bankruptcy. They'll tell you the family home you poured your heart into is a money pit with a faulty foundation. Their entire strategy, orchestrated by their lawyer, is to create a narrative of depreciation and decay, to convince a judge that the golden goose is, in fact, a sickly chicken. Your lawyer's job, before a single paper is filed, is to become the ultimate truth teller. They are the ones who have to dismantle this false narrative piece by piece and build an unshakable case for the real value. Let's start with what seems simple: the house. You both know what you paid for it. You can go on Zillow and get an estimate in 30 seconds. Simple, right? Absolutely not. In a contested NYC divorce, a Zillow estimate is a joke. Your spouse will hire an appraiser who will find every microscopic crack in the foundation, every outdated appliance, every scuff on the floor. They will emphasize the softening market and produce a report valuing your beautiful brownstone at a shockingly low number. Your lawyer anticipates this. They don't just get their own appraiser. They get the right appraiser. They get the expert who has testified in court 100 times, whose reputation is sterling, and who knows precisely how to document the custom renovations, the desirable school district, and the recent comparable sales that your spouse's appraiser conveniently ignored. Your lawyer is now armed for a battle of the experts, ready to cross-examine the other side's appraiser and expose every flaw in their logic, every biased assumption in their report. This isn't just about getting a higher number. It's about establishing credibility. It's about showing the court from the very beginning which side is dealing in reality and which is dealing in fiction. Now let's move to the stock portfolio. The numbers are right there on the screen. $1 million in Apple stock is $1 million in Apple stock. How can there be a fight? Oh, there's a fight. The fight isn't about the value. It's about the date of valuation. In New York, the value of assets is typically determined on a date somewhere between the start of the divorce and the day of the trial. A savvy spouse, seeing a market downturn coming, might try to rush to file and lock in a low valuation date for their massive stock portfolio. A week later, the market rebounds, the portfolio is worth $200,000 more, but they'll argue the locked-in lower value is what should be divided. Your lawyer's job is to fight this, to argue for a valuation date that is fair and truly reflective of the asset's worth, preventing your spouse from profiting off market volatility at your expense. But the real bare-knuckle brawl happens with the privately owned business. The restaurant, the marketing agency, the dental practice. These are the crown jewels, and they are the easiest assets to manipulate. There's no public stock price. Its value is a matter of opinion, and your spouse will pay a lot of money for an opinion that says their business is worth next to nothing. This is where your lawyer transitions from a legal strategist to the general of a small army of forensic experts. Imagine this scenario. Your husband owns a chain of successful artisanal bakeries in Manhattan. For years, you've seen the lines out the door. You handled the books in the beginning. You know it's a cash cow. But now, as you contemplate divorce, he starts singing a different tune. Business is terrible, he says. The pandemic, inflation, rising rents, we're barely hanging on. He shows you financial statements that back him up. Profits are way down. The business looks like it's on life support. You start to doubt yourself. Maybe he's right. Maybe there's nothing left to divide. This is the moment your lawyer brings in the forensic accountant. This isn't your neighborhood CPA. This is a financial bloodhound, and your lawyer points them in the right direction. They don't just look at the profit and loss statement. They tear it apart. And what do they find? They find that 6 months ago, your husband put his brother on the payroll as a consultant for $200,000 a year. The brother lives in Florida and has no experience in the bakery business. That's $200,000 of marital profit siphoned out of the business and parked with a family member. They find tens of thousands of dollars in business expenses for lavish dinners, Super Bowl tickets, and a research trip to a 5-star resort in Hawaii. These are personal expenses disguised to slash the business's on-paper profit. They find that he's suddenly decided to prepay a year's worth of rent and purchase a decade's worth of industrial mixers, all to artificially deflate the cash on hand. The forensic accountant, under your lawyer's direction, reconstructs the financials. They add back the bogus salary to his brother. They add back the personal vacations. They normalize the outrageous capital expenditures. They create a picture of what the business actually earns. And suddenly, the struggling bakery is revealed to be the multi-million-dollar enterprise you always knew it was. But that's only step one. Now you have to put a final price tag on it. Your lawyer brings in the next expert, the business valuator. This expert will look at the real financials and apply one of 3 methods. They might use the market approach and find 3 other artisanal bakery chains that recently sold, creating a powerful argument for what a buyer would pay for your husband's business today. Or, and this is often the most powerful, they use the income approach. They look at the real cash flow, the one your forensic accountant uncovered, and project its future earnings. They create a detailed, evidence-backed report that concludes the business isn't worth the $500,000 your husband claims, but $5 million. Your lawyer now holds a weapon of immense power. It's a valuation report that is not based on guesswork or emotion, but on your husband's own numbers, stripped of all the deception. When your lawyer presents this in a settlement negotiation, the dynamic shifts completely. Your husband and his lawyer know they can't possibly refute this in front of a judge. Their narrative has been shattered. The lie has been exposed before the war has even officially begun. This work, this deep forensic valuation, is what prevents you from walking away with pennies on the dollar. It's what ensures you get your fair share of something you helped build. And it gets even more complex. What about the intangibles? What about a surgeon's medical practice? The value isn't just in the MRI machines. It's in the surgeon's reputation, their goodwill. In New York, that professional goodwill can be considered a marital asset to be valued and divided. How do you put a price on a name? On a reputation that brings in millions a year? It's an incredibly complex and contentious fight, and your lawyer needs to have the right kind of valuation expert who specializes in this esoteric field. Or what about the author who has a half-finished manuscript? Or the tech founder with a brilliant piece of code that isn't yet making money? There's no current value, but there is immense potential value. Your lawyer has to craft an argument for your share of that future success, ensuring you aren't cut out of a lottery ticket you helped purchase. This entire pre-filing stage of valuation is about one thing: defining the size of the pie. Your spouse will do everything in their power to convince you, and the court, that you're fighting over a cupcake. Your lawyer's job is to prove that you are, in fact, fighting over a 10-tier wedding cake. They build a fortress of facts, expert reports, and financial analysis so that when the time comes to divide everything, the discussion starts from a place of truth, not from your spouse's self-serving fiction. Once that true value is established, once the real size of the pie is on the table, a new question emerges, one just as critical and just as contested. Who gets a slice? Because just because an asset exists and has value, doesn't automatically mean it's part of the marital pot. The next great battle is determining what is yours, what is mine, and what is truly ours. This is where the entire financial landscape of your divorce is drawn. New York is not a community property state, where everything is presumptively split 50-50. No, New York is an equitable distribution state. And that one word, equitable, is where fortunes are made and lost. Equitable doesn't mean equal, it means fair. And what a court deems fair is based entirely on the arguments, the evidence, and the story your lawyer presents. So, the first rule your lawyer operates under is the presumption. The law presumes that nearly everything acquired from the day you said, "I do," until the day one of you files for divorce is marital property. It doesn't matter whose paycheck bought it. It doesn't matter whose name is on the title of the car or the deed to the house. If it was earned, purchased, or acquired during the marriage, it goes into the marital pot. Your salary, your spouse's salary, the home you bought together, the retirement accounts you both funded, the stock portfolio you built, it's all presumed to be marital property subject to equitable distribution. That's the starting point. It's a vast, all-encompassing net. But the real work, the strategic chess match, is about what's not in that net. This is the realm of separate property. Your lawyer's job is to meticulously identify and then fiercely protect every single asset that qualifies as separate property, because separate property is yours. It is not subject to distribution, stays with you off the table. So what qualifies? The law carves out very specific exceptions. First, anything you owned before the marriage. That brokerage account you had in your 20s, the condo you bought when you were single, that's your separate property. Second, any inheritance you and only you received during the marriage. Your grandfather leaves you his classic car in his will? That's yours. A bequest of stock from a beloved aunt? Yours. Third, gifts received during the marriage from anyone other than your spouse. Your parents give you $50,000 for a down payment on a house, and they make it crystal clear in writing that the gift is to you alone? That's your separate property. Fourth, compensation for personal injuries. If you received a settlement from a car accident for your pain and suffering, that portion is typically considered yours. Sounds simple, right? A clear, bright line. But this is where the bright line gets blurred into an impressionist painting, and this is where having a lawyer before you file becomes absolutely critical. The single greatest threat to separate property is a concept called commingling. Commingling is what happens when you mix separate property with marital property, to the point where it can no longer be traced or identified. Think of it like putting a single drop of red dye into a gallon of clear water. Eventually, the entire gallon is faintly pink. The original drop is lost forever. Let's play this out. You inherit $100,000 from your grandmother. That's your separate property. You deposit it into a brand new, separate bank account that only has your name on it. You don't touch it. 10 years later, you file for divorce. That $100,000 plus any passive interest it earned is still your separate property. You protected it. But what if you deposited that $100,000 into the joint checking account you share with your spouse? And for the next 10 years, both of your paychecks are deposited into that account. You pay the mortgage, the groceries, the car payments, the vacations, all from that account. The money gets mixed. Marital funds go in, marital expenses go out. 10 years later, can you prove which of the dollars currently in that account are your separate inheritance dollars? It's almost impossible. You've commingled it. You've turned your separate property into marital property. You inadvertently made a gift to the marriage. That drop of red dye is now part of a pink sea. A lawyer's pre-filing job is to become a financial archaeologist. They will work with you and sometimes with forensic accountants to trace the money. They'll pull years of bank statements looking for that initial deposit. They'll try to follow the flow of funds, to argue that even though it was mixed, its separate character was never intended to be destroyed. This is painstaking, detail-oriented work that can mean the difference between keeping your inheritance and having it split. But it gets even more complex. Let's talk about transmutation. This is when separate property changes its character not through mixing, but through action. Let's go back to that condo you owned before the marriage. It's your separate property. A few years into the marriage, you decide to refinance the mortgage, and the bank requires your spouse to be on the new deed. So you sign a new deed transferring the property from just your name to both of your names as joint tenants. You have just taken your separate property and with the stroke of a pen, likely transformed or transmuted it into marital property. The law will often presume you intended to make a gift to your spouse of half the value of your condo. Your lawyer's job before filing is to analyze that transaction and see if there's any way to argue that it wasn't a gift, that it was done for financing purposes only, and that the separate nature of the original equity should be preserved. And then there's the final boss level of this analysis, the appreciation of separate property. This is one of the most litigated issues in New York divorce law. Let's say you started a small consulting business a year before you got married. It was worth, say, $50,000. That $50,000 is your separate property. Now, 15 years later, you're getting divorced and that business is worth $5 million. The question is, who gets the $4,950,000 of growth? The answer depends on why it grew. New York law makes a distinction between passive appreciation and active appreciation. Passive appreciation is growth that happens because of market forces, inflation, or other factors that have nothing to do with the efforts of you or your spouse. for example, if you owned a piece of land before the marriage and you did nothing to it, and a new highway gets built nearby causing its value to skyrocket, that's passive. That appreciation remains your separate property. But active appreciation is different. Active appreciation is the growth in value that results from the contributions or efforts of either spouse during the marriage. So, with your consulting business, did you spend the last 15 years working 80-hour weeks to build it? Did you reinvest marital funds back into the company? Did your spouse contribute, even indirectly? Maybe they handled the household, raised the children, entertained clients, which enabled you to focus on growing the business. If the answer is yes, then that appreciation, that massive growth in value, is marital property. The court will see the marriage as a partnership, and your spouse's indirect contributions are recognized as having supported the business's growth. So the pre-filing legal work becomes a deep investigation. Your lawyer will be gathering evidence to show how much of that growth was active versus passive. They'll look at your time and effort, your spouse's contributions, market trends in your industry, everything. They might need to hire a business valuator to prepare a report that separates passive market growth from the growth that came from your marital efforts. This isn't just a legal argument. It's a complex financial calculation that defines the battlefield. Do you see the pattern here? The law sets up these presumptions and categories, but real life is messy. Money flows, assets get mixed, names get added to deeds, businesses grow. The role of your lawyer in this crucial pre-filing stage is to untangle this web. It's to analyze every major asset and ask, what is its origin story? Was it separate? Did it remain separate? Was it commingled? Did its value grow, and if so, why? This process of classifying every single asset as marital, separate, or a hybrid of the two is the foundation upon which your entire financial settlement will be built. Getting this wrong or failing to do this work up front is like building a skyscraper on a foundation of sand. It will inevitably collapse under the pressure of litigation. But once you have fought this battle of classification, once you have sorted the yours from the mine and the ours, a new, and in some ways even more contentious question comes into focus. What is it all actually worth? Because a Monet on the wall, a business on paper, or a pension on the horizon are only valuable in a divorce if you can prove their price tag. And that's a fight all its own. It's a battle fought not with raised voices in a courtroom, but with spreadsheets, expert reports, and quiet, methodical investigation. This is the valuation phase, and it's where your lawyer transforms from a legal advisor into the general contractor of your financial future. Because before you can argue about who gets what, you have to agree on what is actually worth. And that agreement is rarely, if ever, a given. Let's start with the most common battleground, the family home. You might think easy, I'll just check Zillow. But in a New York divorce, a zestimate is about as legally binding as a weather forecast. Your lawyer knows that the true value of your home is a strategic number, not a public estimate. They'll advise on hiring a certified real estate appraiser, someone whose entire career is dedicated to producing a number that can stand up to scrutiny in court. But here's where the strategy kicks in. Your spouse will hire their own appraiser. And shocker, their appraiser will likely come back with a very different number. One might value the house high, maybe because your spouse wants to be bought out for a bigger check. The other might value it low, perhaps because you want to keep the house and buy them out for less. Suddenly, you're not just looking at a house, you're looking at a valuation gap of $50,000, maybe $100,000. Your lawyer's job is to dissect both appraisals, find the weaknesses in your spouse's report, and build a powerful argument for your number. They're looking at comparable sales, market trends, and even the cost of necessary repairs that could impact the value. This isn't just about a house. It's your first major lesson in divorce math. There is no one true number. There is only the number you can prove. Now let's leave the relative simplicity of a house and step into the real jungle. Valuing a business. Imagine one spouse is a partner in a successful downtown restaurant. How do you value that? It's not just the cash in the register or the value of the kitchen equipment. It's the brand, the reputation, the goodwill that keeps customers coming back. How do you put a price tag on a feeling, on loyalty? You don't. You hire a forensic accountant. This is a specialized financial detective that your lawyer brings in. Their job is to dive deep into the business's books, often for years back, to find its true value. They're looking for things your spouse might not want you to see. Did they use the business account to pay for personal vacations? Are they suppressing income to make the business look less profitable on the eve of a divorce? Are they paying a salary to a family member who doesn't actually work there? I had a case once where a husband owned a modestly successful construction company. He claimed it was barely breaking even, that the market was tough, and its value was tied up in heavy machinery that was rapidly depreciating. On paper it looked bleak. But his wife's lawyer got a feeling. She insisted on bringing in a forensic accountant. The accountant spent weeks combing through invoices, bank statements, and project bids. And what did he find? A completely separate set of books. A shadow ledger showing millions in cash transactions that were never reported. The struggling business was a cash cow. That one move, that single decision by the lawyer to not take the numbers at face value, completely changed the trajectory of the divorce, securing the wife's financial future for decades to come. Your lawyer's experience tells them when the story doesn't match the numbers. They know which experts to trust and how to deploy them to uncover the truth. This same principle applies to professional practices like for a doctor, a dentist, or even another lawyer. The value isn't in the office furniture. It's in the professional license, the patient or client list, and the years of established reputation. New York law recognizes that a professional license earned during the marriage is a marital asset subject to division. Valuing that license and the practice attached to it is an incredibly complex art, requiring experts who can project future earnings and put a concrete number on abstract concepts like reputation. Without a lawyer guiding this process, you would simply be leaving an enormous amount of money on the table, money you are legally entitled to. Then there are the financial assets that seem straightforward but are secretly complex. Retirement accounts, a 401k, an IRA, a pension. You might look at the statement and see a balance of, say, $500,000. You think, great, I get half of that. Not so fast. The crucial question is, how much of that was earned during the marriage? Any money that was in the account before the wedding, and any growth on that premarital portion, is likely separate property. Your lawyer's job is to perform a meticulous tracing of funds. They'll gather statements going back to the beginning of the account to precisely calculate the marital portion. For pensions, it's even more complicated. You're not valuing a pot of money that exists today. You're valuing a promise of future payments. This requires an actuary to calculate the present value of that future income stream. They'll then need to draft a special court order, a qualified domestic relations order, or QDRO, to ensure the pension administrator divides it correctly. This is not a DIY project. A single mistake in a QDRO can be irreversible and cost you tens or hundreds of thousands of dollars down the road. And finally, we have the weird assets, the things that don't come with a monthly statement. The art collection your spouse amassed, the vintage cars in the garage, the valuable wine or whiskey collection in the cellar, the intellectual property from a book they wrote or a patent they filed, even cryptocurrency. Each of these requires a niche appraiser. Your lawyer orchestrates this entire symphony of experts. They find the art historian, the classic car expert, the crypto analyst. They coordinate their work and, most importantly, they synthesize it into a single coherent financial picture of your marriage. Think of it this way. Filing for divorce without a comprehensive valuation of your assets is like trying to navigate a ship through a treacherous storm with no map and no compass. You are sailing blind. The pre-filing stage is your time to draw that map. Your lawyer helps you identify every island, every reef, every hidden treasure. You might think you know what you both own, but you'd be amazed at what a thorough, professionally guided discovery process can uncover. Assets you forgot about, assets you never knew existed, and assets that are worth exponentially more than you ever imagined. By putting a price tag on everything before the first legal papers are even filed, you transform the entire dynamic. You are no longer reacting from a position of ignorance and fear. You are operating from a position of knowledge and strength. You know exactly what's at stake. You can make intelligent settlement offers, and you can recognize a bad one the moment you see it. This valuation work isn't just a preliminary step. In many ways, it's the whole game. It sets the financial foundation upon which every subsequent decision will be built. So you've done it. You and your legal team have created a master inventory. You've placed a defensible, expert-backed number on the house, the business, the retirement funds, and the rare comic book collection. You have a clear picture of the marital pie. But a balance sheet has two sides. You've tallied up all the assets. But what about everything you owe? Because in a New York divorce, your credit card bills, your mortgage, and your student loans get a seat at the table too. And figuring out who is responsible for that mountain of debt is a battle just as fierce as the one for the assets. Let's talk about the anatomy of debt in a New York divorce. It's not a simple ledger of who owes what. It's a tangled web of promises, obligations, and legal definitions that can either anchor you to your ex for years or set you free. And your lawyer? Their first job is to become a financial archaeologist, digging through the layers of your shared financial history to determine the origin and purpose of every single dollar you owe. The first, most crucial distinction your lawyer will make is between marital debt and separate debt. It sounds simple, but this is where divorces get incredibly messy. Marital debt is generally any debt incurred by either spouse during the marriage. Notice I said either spouse. It doesn't matter whose name is on the credit card statement or the car loan. If you bought a new living room set on your Visa card while you were married, that's almost certainly marital debt. If your spouse took out a personal loan to pay for a family vacation to Disney World, that's marital debt. Why? Because it was for the benefit of the marital partnership. The law views your marriage as a business, and debts taken on to run that business are a shared responsibility. This is a gut punch for a lot of people. You might have been the frugal one, the saver, while your spouse was the spender. You might have begged them to cut up the credit cards. But if those debts paid for groceries, kids' clothes, home repairs, or anything that supported the family's lifestyle, New York law says you both benefited, and you are likely both on the hook. Your lawyer's job isn't to argue that it's unfair. The judge has heard that 1,000 times. Their job is to prove with evidence which debts were truly for the marriage and which were not. And that brings us to the second category, separate debt. This is debt you had before you walked down the aisle, like your old college student loans. Or it can be debt incurred after the date of separation. But here's the most contentious part. It can also be debt incurred during the marriage that served no marital purpose. This is where your lawyer puts on their detective hat. Imagine your spouse has a $20,000 credit card bill that they've been hiding from you. You discover it during the divorce process. Your first instinct is panic. Am I responsible for half of this? Your lawyer's first question will be, what was the money spent on? They will subpoena the statements. They will go through them line by line. Were the charges for dinners with a secret lover? A gambling habit you knew nothing about? A solo shopping spree for luxury goods that were kept hidden from you? If your lawyer can prove that these funds were spent solely for your spouse's personal benefit, completely unrelated to the marriage, what we call marital waste, they can make a powerful argument that this debt is theirs and theirs alone. This isn't just about finding a receipt for a hotel room. It's about building a narrative, supported by evidence, that demonstrates a pattern of behavior that was detrimental to the marital partnership. It's about showing the judge that this wasn't a business expense for the marriage incorporated. It was embezzlement. Now let's talk about the gray areas, because this is where a great lawyer earns their fee. What about student loans? Let's say you came into the marriage with $50,000 in student loan debt. That's your separate debt, right? Mostly. But what if, for 10 years, you used money from your joint checking account marital funds to make the monthly payments? Your spouse's lawyer will argue that marital money was used to pay down your separate debt, and they will want a credit for their client's half of those payments. And they might get it. Or let's flip it. What if your spouse went to law school during the marriage? You supported them. You paid the bills, took care of the kids, and racked up $150,000 in loans so they could get that degree. Now you're getting divorced. That law degree is considered a marital asset in New York, something with tangible value that can be appraised. But what about the massive loan that came with it? Your lawyer will argue that the debt incurred to obtain a marital asset should be a shared responsibility, especially if you're going to get a share of the value of that degree. It's a complex, three-dimensional chess game, and every move has a financial consequence. The process of untangling this isn't a simple conversation. Your lawyer initiates what's called discovery. They don't just ask your spouse for a list of debts. They serve legal demands for documents. They get every loan application you've both signed for the last 10 years. They get every credit card statement. They look at the HELOC, the home equity line of credit, and trace where every single dollar went. Did that $50,000 draw pay for the new roof? Or did it mysteriously vanish into an account you never knew existed? Following the money is everything. Once your lawyer has this complete financial picture, the strategy sessions begin. This isn't just about dividing the debt down the middle. It's about strategic allocation. For example, maybe you want to keep the house. The house has a $200,000 mortgage on it. Your spouse has $40,000 in credit card debt. Your lawyer might propose a trade. You take sole responsibility for the entire mortgage, refinancing it into your name, and in exchange, your spouse takes sole responsibility for all their credit card debt. This can be a win-win. You get the house and they get to walk away from the mortgage obligation. But this is where a massive warning sign comes up. You have to understand the difference between what a divorce decree says and what your creditors say. Let's say the judge orders your ex-spouse to pay the $300 monthly bill for the joint Best Buy credit card. Your name is on that account. Your ex decides to stop paying. Does Best Buy care what your divorce decree says? Absolutely not. All they know is that your name is on the account, and you are legally liable for the entire balance. If your ex defaults, they will come after you, and they will report it on your credit report. Your credit score could be obliterated because of your ex's irresponsibility. A good lawyer anticipates this nightmare scenario. They will build protections into your settlement agreement. They might insist that all joint debts be paid off from marital assets before the divorce is final. Or they'll include an indemnification clause, which is a legal tool that says if your ex fails to pay a debt assigned to them and the creditor comes after you, you can take your ex back to court to be reimbursed for what you had to pay, plus your attorney's fees. It's not a perfect shield, but it's a critical sword to have if you need it later. This pre-filing stage is about a deep, forensic audit of your financial life. It's about understanding that a mortgage isn't just a debt, it's leverage. A credit card bill isn't just a number. It's a story of how you lived. Your lawyer's role is to read that story to find the subtext, and to use it to write a better, more secure next chapter for you. They are protecting you not just from your spouse, but from the long-term financial fallout that can haunt people for a decade after the papers are signed. And while this financial war is being mapped out, while you're fighting over spreadsheets and bank statements, there is often a much more delicate, and frankly more important situation unfolding in the next room. Because the cold, hard math of assets and debts is one thing. But when you start discussing the lives and futures of your children, the math gets thrown out the window. The fight over who gets the 401k is nothing compared to the fight over who gets the kids on Christmas morning. And the strategies your lawyer must employ to protect them, and your relationship with them, are infinitely more complex. Let's talk about what that complexity actually looks like. In New York, the court doesn't care about who's right or who's wrong in the marriage. It doesn't care who had the affair or who spent too much money. When it comes to your children, the court has one and only one guiding principle: the best interests of the child. That phrase sounds warm and fuzzy, but in a courtroom, it's a legal battleground. And your lawyer's job, before anything is ever filed, is to build a fortress on that battleground with you standing firmly inside it. So what does best interests even mean? It's not about what's best for you. It's not about what's best for your spouse. It's a dozen different factors the judge will weigh. Who has been the primary caregiver? Who takes the kids to the doctor? Who helps with homework? Who knows the names of their friends and their teachers? Which parent can provide a more stable home environment? Not a richer home, a more stable home. The court looks at the history. It looks at the reality of your family life, not the story you want to tell. This is where the pre-filing strategy becomes absolutely critical. Your lawyer will tell you that from this moment forward, you are creating the evidence that a judge will one day review. Every decision you make matters. Let me give you the single most devastating mistake people make, a mistake that a lawyer can help you avoid. It's called creating a status quo. Courts are incredibly reluctant to disrupt a child's life. They want stability above all else. So the living arrangement and parenting schedule that exists right before you file for divorce becomes a powerful default setting in the judge's mind. This is the status quo. Let's imagine a husband, we'll call him Mark. Mark and his wife are fighting constantly. The house is full of tension. He thinks, I'll be the good guy. I'll move out to give us some space. I'll stay at my brother's place for a few weeks to let things cool down. He thinks he's de-escalating the conflict. What he has actually done is just handed his wife the most powerful piece of evidence she could ever ask for in a custody battle. He has, with his own 2 feet, established a status quo where the children live with their mother 100% of the time, and he is the visiting parent. When he finally files for divorce 2 months later and says, Your Honor, I want a 50-50 shared custody schedule, her lawyer will stand up and say, Your Honor, with all due respect, the children have been living with my client full-time for the past 2 months. They are stable, they are in their home, their routines are established. To uproot them now for a 50-50 schedule would be disruptive and chaotic. The current arrangement is working, and it's in the best interests of the children to maintain it. Mark didn't abandon his kids. He was trying to keep the peace. But in the cold logic of family court, he created a precedent. He created the status quo. A good lawyer in that very first meeting would have told him, Do not move out of the marital home without a written signed parenting agreement in your hand. If you must leave, we need to establish the schedule before you go. That one piece of advice can be the difference between being a weekend visitor and being a co-parent. This pre-filing period is when your lawyer helps you build your story. Not with words, but with actions. They'll tell you to start a journal. Document every single parenting activity you do. Log the times you pick them up from school, the parent-teacher conferences you attend, the doctor's appointments you handle. Take pictures at the park. Keep receipts for the clothes you buy them. This isn't about being petty. It's about creating a factual record that refutes any potential claim that you were an uninvolved parent. If your spouse has always handled all the medical appointments, your lawyer will advise you to start scheduling them yourself to get on the school email list to become the primary contact. You are actively demonstrating your commitment in a way that is verifiable and undeniable. We also have to talk about the two types of custody in New York: legal and physical. Physical custody is what most people think of. It's where the child physically lives. But legal custody is just as, if not more, important. Legal custody is the right to make major decisions about your child's life. Healthcare, education, and religious upbringing. Do they get braces? Do they attend public or private school? Will they be raised in a specific faith? Ideally, the court wants parents to have joint legal custody, forcing you to make these big decisions together. But if one parent can prove that the other is obstructive, unreasonable, or incapable of co-parenting effectively, a judge might award sole legal custody. Your lawyer in this pre-filing stage will be advising you on communication. Every email, every text message with your spouse about the kids could become evidence. They will coach you to be reasonable, to be child-focused, to propose solutions, and to document every time your spouse is the one being difficult or refusing to communicate. You are building a case, email by email, that you are the parent who can and will act in the child's best interest, even when it's hard. And then there are the darker strategies your lawyer must prepare you for. What if your spouse starts whispering things to the children, trying to turn them against you? This is called parental alienation, and it is poison. A lawyer will tell you how to recognize it and, crucially, how to respond without engaging in the same toxic behavior. The answer is not to fight fire with fire. The answer is to document it, to get the children into therapy with a neutral professional, and to continue being the stable, loving parent, creating a stark contrast for the court to see. What if your spouse threatens to move out of state with the kids? This is the nuclear option in a custody battle. In New York, this is called relocation, and it is incredibly difficult to get a court to approve, but the threat alone is terrifying. Your lawyer's immediate advice will be to take steps to ground the child's life in their current location. Ensure they're enrolled in local activities, that their doctors and dentists are here, that their entire support network is here. This makes a potential argument for relocation much weaker. All of this, avoiding the status quo trap, documenting your involvement, managing communication, and defending against alienation or relocation. This is the real work of a divorce lawyer concerning children. And it all happens before the case even has a docket number. This isn't about setting up a fight. It's about protecting your children from the fight. It's about ensuring that when the legal process does begin, it proceeds from a position of strength, stability, and truth, centered on what is genuinely best for the most important people in your life. The goal isn't just to win time with your kids. It's to preserve the health and well-being of your family, even as it changes shape. And so, we arrive at the ultimate purpose of all this preparation. It's not about legal maneuvering for its own sake. It's about building a new reality, a reality where your children can thrive, free from the crossfire of conflict. A reality where they see two parents who, though no longer married, can still prioritize their well-being above all else. This meticulous, often difficult work you do behind the scenes, guided by your counsel, is the single greatest gift you can give your children during this tumultuous time. It is the act of building them a bridge to a stable future, even as the ground beneath your own feet is shaking. Now let's pull the lens back. We've journeyed through the intricate, often invisible landscape that exists before a single divorce paper is ever filed. We started in a place of confusion and fear, that gut-wrenching moment when you realize your life is about to change forever. From there, we moved into the world of discovery, not as a weapon but as a flashlight. Your lawyer became your financial cartographer, helping you map the complex terrain of your marital estate. We talked about the numbers, the accounts, the assets, and the debts, but it was never just about the numbers. It was about understanding the economic story of your marriage so you could write a fair and equitable final chapter. This wasn't about greed, it was about clarity. It was about ensuring that the future you build is on a foundation of fact, not assumption. Then we built the fortress, We discussed how your lawyer helps you secure your perimeter, ethically and legally. We talked about separating finances, understanding what constitutes marital versus separate property, and ensuring that the resources you've both built are preserved, not squandered in a fit of anger or panic. This is one of the most misunderstood parts of the process. From the outside, it can look aggressive, but from the inside, it is an act of profound responsibility. Your lawyer's guidance here prevents the catastrophic mistake of letting emotion drive financial decisions. They are the calm, strategic general guiding you to protect your supply lines before the battle even begins, ensuring you have the resources to not just survive the process, but to flourish after it. We then navigated the treacherous waters of communication. Your attorney's role here shifts from financial analyst to master strategist. They teach you a new language, the language of de-escalation, documentation, and strategic silence. Every text, every email, every conversation becomes a piece of a larger puzzle. With their counsel, you stop reacting and start responding. You learn to create a record not of animosity but of your own reason, your own stability, your own unwavering focus on what's right. This transforms you from a participant in the drama to an observer of it. You build a wall of evidence with bricks of composure and mortar of facts, a wall that will stand firm against any emotional onslaught your spouse might launch in court. And just now, we touched on the most sacred ground of all, your children. We saw how the lawyer's role evolves again, becoming that of a protector of your parental rights, and more importantly, a strategist for your children's emotional security. The work you do here, creating a status quo of stability, documenting your involvement, and focusing on the children's best interests, is the bedrock of your entire custody case. It's about showing, not just telling, a judge that you are, and have always been, the safe harbor in your children's lives. So when you weave all these threads together, the financial clarity, the asset protection, the strategic communication, the child-centric planning, what do you have? You have a comprehensive, multi-layered strategy. You have a blueprint for your future. This is the paradigm shift that a great lawyer facilitates before filing. They help you transform the divorce from something that is happening to you into a process that you are actively managing. You move from a position of weakness to a position of strength. Not the strength of aggression, but the quiet, unshakable strength of preparation. Think of it this way. Without a lawyer's guidance, filing for divorce is like setting sail in a hurricane in a small raft. You're at the mercy of the wind and the waves, tossed about by your spouse's demands, your own emotions, and the court's unpredictable currents. But with this pre-filing preparation, you're no longer in a raft. You are the captain of a battleship. Your hull is reinforced with financial documentation. Your navigation systems are calibrated with a clear legal strategy. Your communications are your shield, deflecting incoming attacks. You know your destination, a secure, stable future, and you have charted a precise course to get there. The storm may still rage, but you are no longer a victim of it. You are navigating it. This is especially critical here in New York City. The stakes are astronomically high. We're talking about complex compensation packages, valuable real estate, family businesses, and a cost of living that leaves no room for error. The NYC courts are overburdened, and judges have little patience for messy, unprepared cases. When you walk in with a case that is meticulously organized, where the financials are clear, the timeline is documented, and your goals are reasonable, you are sending a powerful message. You are telling your spouse, their attorney, and the court that you are serious, you are prepared, and you will not be lowballed or intimidated. More often than not, this level of preparation is what leads to a favorable settlement out of court. You make the prospect of fighting you so daunting, so expensive, and so likely to fail, that a reasonable agreement becomes their most logical choice. You win the war by preparing so thoroughly that the major battles are never fought. So, what is the ultimate role of a lawyer before filing for divorce? It is to be your architect. They help you design the scaffolding for your new life before you demolish the old one. They are your strategist, seeing the entire chessboard and thinking 10 moves ahead, while you're just trying to get through the day. They are your shield, absorbing the legal and emotional attacks so that you can focus on your work, your health, and your children. They are your translator, converting the confusing, intimidating language of the law into a clear, actionable plan. The work done in these quiet, unseen months is the most important work of your entire divorce. It is what separates a devastating, life-derailing event from a difficult but manageable transition. It is the difference between a future defined by regret and a future defined by you. Your journey to a new life doesn't start the day you file for divorce. It starts the moment you decide to be prepared. It starts with a single confidential conversation. It's a step not of aggression, but of profound self-respect. It's an acknowledgement that you and your future are worth fighting for, and that the best way to fight is to prepare with wisdom, strategy, and foresight. The end of a marriage feels like a conclusion, but with the right guidance, it is not the end of your story. It is the end of a chapter. And the work you do now, before the world even knows, is you sitting down and deliberately, carefully, and powerfully writing the first words of the next one. This is your chance to turn the greatest crisis of your life into the catalyst for your greatest comeback. Don't just go through a divorce. Strategically navigate it. Take control of your narrative. Build your new beginning.